When there is a weak case against a poor and scared defendant, it is common practice to say, okay, buddy, if you plead guilty, I'll let you off with probation. Otherwise, I'm going to add a felony charge and put you in prison. The end result is that many people have a criminal record for something they did not do, and the prosecutor gets reelected. Is this what you're going to do? That's my first question to both of you.
I can start with that. And I understand what you're saying. Basically, it's bully prosecution. Basically, if you exercise any of your constitutional rights, then we're going to beat up on you and we're going to go after you. I don't think that's a way to practice law. I think a prosecutor should evaluate a case on its merits. Because I can tell you this, the entire legal community, not the entire, but a lot of legal community is very much opposed to the state attorney's office because they do exactly that. They'll say, if you do any depositions, you know what? We're going to up the charges and we're going to go after you, or we're going to withdraw the plea offer. I'm going to have a policy at the state attorney's office. They don't have it now, but and something that's very common sense. If you have a prosecutor who prosecutes somebody knowing that the person is innocent, they're going to be looking for a new job.
Well,
And
first, let me just say that I disagree with his policy, and I think it's not sound practice. First, we ethically, our prosecutors, and what I will enforce is our prosecutors, we're very ethically bound by the law and making sure that our prosecutors believe that they have violated the law. And if they don't, they have no business pursuing the case.
Yeah,
now,
well, why have you been doing that all
well,
along?
let me tell you about one of the examples.
Answer the question.
That's what I'm
Why
going.
have you been doing that all
be
along?
respectful.
Well,
I know
that.
some people in the courthouse, and they tell me what you do is common practice.
Right, well, that's what I was going to say. One of the things that does occur, it does occur that that sometimes in plea negotiations, if a defendant accepts responsibility for what they've done, then a particular sentence will be structured. An example that sometimes happens is in child sex cases. When these sexual monsters go after a child and they abuse a child, that will sometimes be a negotiating tool, is if they don't take the deposition of the child and put that child
Say
through trauma.
negotiated, you mean threatened.
You say what it, you can call it what you want, but it's what we do, sir.